Hey there, I'm Paul Rabelais, and in this video we're going to talk about how to bequeath those personal effects. So I'm Paul Rabelais, I'm an estate planning attorney, help our clients in Louisiana get and keep their legal affairs in order. A lot of times I've been helping people over the years and work with a couple, and we're talking about their house and their investments and all those things that have significant fair market value and concrete value. And then perhaps towards the end of the conversation, the wife, for example, might turn to me and say, well, Paul, what do we do about all our stuff and all of our personal effects? And she might say something like, well, my husband, Gary, he's got a bunch of old guns, and I'm sure he'd want our son to get all of those guns. And I got mama's fine china, and my daughter said she'd like to have that, but she doesn't want to fight my daughter-in-law for it. What do we do about all that? So that's just, sampling of a conversation of, how I spend my day. But for some families, it's really important to get all this stuff right. The money is easy to split, if you have 2 children or 4 children or 3 children, and there is, $3,000 to split up, piece of cake. Everybody gets, their share. But when there's a diamond engagement ring that has significant value and you can't divide that up, what do? So what I'm going to share with you is just the 3 different ways families handle it. And right, wrong, or indifferent, this is just how they do it. So the first way that families handle it, quite frankly, is to do nothing about it. So yes, they have their estate planning legal documents in place, which are necessary to control the disposition of all of those titled assets, like real estate, like investments, like accounts, even like vehicles that are titled at the Office of Motor Vehicles. And they really, all those legal documents are silent regarding all the personal effects and the furniture and the clothing and all that. Those are non-titled. So when mom leaves things to her 3 children and she dies, oftentimes the 3 children just get together and figure it out. Hey, you take this, I'll take this, you take this, blah, blah, blah. And so they don't really need any legal documents when they can agree among themselves to take physical possession of those non-titled personal items. So in one instance, people say nothing about it in the legal documents. They do nothing. They just kind of hope that it works out. Often it does work out. Sometimes it doesn't. Nonetheless, the legal documents say everything goes to the 3 children equally, and if it gets sticky and hairy, then it may come up to some judge, which it rarely does, but sometimes it does, to determine how those things get divided up, or sometimes they have to be sold, so the proceeds of the sale can be divided 3 ways. So that's option 1. Just do nothing and hope that the kids work it out. Option number 2 is to do something about it, be a little more proactive, but have what you do be informal. So for example, you have all the formal legal documents, wills and trusts, and that where you leave things to the 3 children equally. But then you may have kind of a letter on the side, or a list on the side, or people tell me they use their Post-it notes to put underneath the dining room table. And none of that stuff has really legal effect, but it's a communication to your children as to how you'd want those non-titled personal effects to go. And oftentimes when the children see that you've made an attempt to communicate your wishes to them, they'll typically honor those wishes. So I'd say that probably is what people do most, is they informally communicate. And in fact, when we put our clients' legal documents together, we create an extra section in their portfolio binder where they can informally kind of list how they'd want certain things to go. They can add to it, they can change it, they can scratch things out. It's not a legal document. It's just a communication to their family about their personal effects and how they'd like to see their heirs or their children handle those things. So option 2 is just the informal writing. And again, I've heard people say, well, we just instructed our children to do like a draft, just like they do in the NFL. But we instructed our children because this is how we did it when our parents died. we instructed our children to go 1, 2, 3, 3, 2, 1, 1, 2, 3. So there's, and then other people say, well, we just had them, we hope that our children will follow our wishes to do a lottery. So they'll pick who goes first, 1, 2, 3, and then they'll just pick things in order. So there's a lot of different ways to handle it informally. And then the third way to do it, and the beauty about number 2, informal, you can change that anytime. You can change your mind. You can add to your list. You don't have to come back to the lawyers and change all of your legal documents just because you bought a new frog at the ceramic store and you want to leave that to your granddaughter. But the third way to do it is to do it formally. And that's where in your legal documents, the husband's going to say, I'm leaving my guns to my son. And the wife is going to say, I'm leaving my china collection to my daughter. So then it's really etched in stone, can't be successfully challenged. And it's going to happen that way. So, we'll see people choose that option and go that route oftentimes when they feel like someone's going to object, to just agreeing to divide things up. So becomes real important then to do it the right way. Yes, if you change your mind or if you want to add something to that formal list, you've got to really get back in touch with the lawyers and you've got to do some type of trust amendment, some type of will codicil, which is an amendment to the will. And so the formal way to do it, you gotta, when you want to change it, you got to get back with the lawyers, but sometimes it needs to be that way because you need to be specific because there might be problems when you pass away if you're not specific. So those are the 3 general ways that personal items are bequeathed. Oftentimes parents, they have a bunch of junk, they have an old bed and the kids don't want any part of it. But sometimes, either stuff has significant monetary value or significant emotional value or sentimental value. So it becomes important to address that as part of the overall estate planning program. So hope that helps. I could go on for a little more, but I think you get the basics. You can do nothing and it's non-titled. The kids will work it out if you're leaving things to kids. You can do it informally, just some letter of instructions or some communication outside of the legal documents. They'll honor your wishes, hopefully. And then third is to do it formally and put it in the legal documents. Just if you need to change that, you need to amend your your estate planning legal documents appropriately. While I'm thinking about it, make sure you punch the subscribe button. I got a lot more to offer, and if you hit the subscribe button along with the bell notification next to it, that way YouTube will do its things to keep you somewhat posted of future educational videos that we put out. Make sure you punch the like button that tells YouTube that, hey, let's show this guy's videos to a few more folks. I'm Paul Rabelais. Have a great day.